speaker will be Lee Holloway, and she's program manager for Milwaukee River Keepers. She's going to be talking about the long time work that they've been doing on turning the tide on plastics. In Milwaukee, there's lots of people who are trying to back off of and find ways to not use the plastic so much. So she's working on that. So she'll be here next Sunday. And right now, our speaker today will be introduced by Jerry Fredrickson. He's one of our group members.
Thanks, Lorraine. It's really a pleasure to have Elizabeth here today. You've probably heard of one call, that's all. Anybody heard that before? Yeah. That's not what this that's not what this law firm is about. And I guess you're familiar with that too. It's a law firm we love to hate and like it. Anyway, Law Forward is one of those organizations that really represents the people. And they are a watchdog for the government and the state, and also obviously the Supreme Court. And if there ever was a time to pay attention to the Supreme Court, it's now. And I'm sure you all voted, and you're going to vote in the next one. And it's very important that we do that. And so Elizabeth is going to speak primarily about the Supreme Court and a little bit about the law forward is. Some of you may be a little bit familiar with law forward because we did have a show to play about a year and a half ago. So, but it's a new organization and we're really glad that they're around. So with that, Elizabeth, please.
Hey, good morning, everybody. Thanks so much for having me, and thanks for the really nice introduction, Jerry. I'm going to try to talk into the microphone as instructed. If you ever can't hear me, please just let me know. And yeah, thank you all for coming out to talk about the Wisconsin Supreme Court. I have a presentation ready, but please do feel free to raise a hand if you have a question as we're going, and I'll be happy to try to address it. And we can obviously have some time at the end for questions as well. There. Oh.
Wait, try that.
Something in the way.
There we go.
Moved her.
I think we got it now. Okay, so Jerry already gave us a really nice introduction, but I'll say a little bit more about Law Forward. Law Forward is a small nonprofit impact litigation firm based in Madison, but serving the whole state of Wisconsin. We were founded a little over 2 years ago, late 2020, and we're pro-democracy, so we're non-partisan, but we exist to protect voters' rights, to make sure that everyone's vote counts equally, and to hold government accountable, to hold our elected government accountable for what it is supposed to do and how it is supposed to work. So we do some work on open records, government accountability. The thing that you might have seen us in the news about, probably most famously, is our work on the fake electors from the 2020 election, the Republican slate of electors that purported to submit electoral votes to Congress after President Biden won. Law Forward filed the first in the nation civil suit against those folks a little while ago. But we're not going to talk about that today. We're going to talk about the Supreme Court. A quick word about me. Again, my name is Elizabeth. I've been at Law Forward for about a year. Originally from the Milwaukee area, so I'm always thrilled to be back home. And before Law Forward, I worked in legal aid. I was at Legal Action of Wisconsin for a couple of years. So my angle into this work is just a very strong feeling that we need a democratically accountable government to best serve everyone in Wisconsin, and particularly our most vulnerable neighbors. There we go. Okay, so I want to start by talking about just what is the Wisconsin Supreme Court, because I don't think it's something that we actually learn that much about in civics education. I don't think I knew they were elected until I was a grown adult. So these are our current 7 Wisconsin Supreme Court justices. They are elected to 10-year terms unless somebody retires or has to leave in the middle of a term, and then there might be an appointment who will then have to stand for election later. They can run again after 10 years. And as I'm sure you all know, it is a nonpartisan race, not that it always feels that way, but in theory, nonpartisan elected judges, what we have on our Supreme Court. There's a lot of like little information in here. We'll get into that more later. But the main thing is just to give you a sense, these are just 7 people. And they have a lot of power in this state, right? They get to make decisions on cases that affect each and every one of us. So what does the court do? One thing it does that I think a lot of people don't think about as much is it actually sets the rules for itself and for the rest of the court system. So for example, the Supreme Court could, if it wanted to, set the rule on recusal. When should you not decide a case? For example, if a party donated a lot of money to your campaign. The rule right now is there is no rule, but that is something that they do have control over. Another example would be, got a former legal aid colleague in the room, and there's a rule petition pending at the Supreme Court about how long should eviction records stay up publicly searchable on CCAP. They get to decide. They can change that rule if they want. So that's a kind of under the radar power that the court has. But of course, the big thing it does is it decides cases that come to it, mostly on appeal. There is a process for filing an original action at the Supreme Court, but mostly cases go through the lower courts, and then if somebody's unhappy with the outcome, gets up to our Supreme Court that way. And I think it's really important to note that our Supreme Court does make law, right? It interprets law and it makes law, and it often changes the reality on the ground. And you'll sometimes hear people talk about how, oh, it's, courts shouldn't be making laws, that's activist judging. But in reality, it's just always been true that our court makes law, and that each of these 7 people brings a specific background and experience and perspective to their work on the court. And so it's really, really important who they are. Okay, for the first time. Okay, so last term, the 2021 to 2022 term of the Supreme Court, Law Forward actually put out a report talking about the Supreme Court's work. And we looked at it from a democracy angle because that's what we do. And that's a report that I spent a lot of time working on, which is why I sometimes do some of these speaking engagements for Law Forward. And we really noticed 3 big trends that we found very alarming for how the court was behaving and the impact that was having on Wisconsin. So that's kind of how I want to structure my presentation, is by going through those one by one. And so this is what they are. The first one we call direct attacks on democracy. That's what it sounds like. That's a ruling that at Law Forward we think it directly impacted whether you can vote. Drop boxes, anyone? It directly impacted how much your vote counts, as well as whether the government is really, working in a democratically accountable way. So we only have 3 cases in that category, but there are 3 big ones, and those are the 3 that I want to kind of talk about today. The second category was about consolidating power at our legislature, which, as I suspect everyone in this room knows, is not a particularly democratically accountable body due to gerrymandering. So there were a number of cases that either directly kind of aggrandized the legislature, sort of deferring to its interpretations and making it more powerful, or had a similar impact by reducing the authority of local governments or other branches of our government. So particularly the governor and the executive branch, which is something that we consider damaging because we're supposed to have 3 branches of government that are kind of balance each other out, right? That's the Schoolhouse Rock vision of government. It's checks and balances. So when you have one branch of government that's really much stronger than the others, and particularly if that's not a democratically accountable branch of government, we think that creates some problems for our democracy. And the third theme that we found was something that we call results-oriented judging. This is the thing that I often have the hardest time explaining, but what we mean by that is that, again, judges are always going to bring their own perspectives to a case, right? We expect that, we understand that, that's why we have elections. But we saw in many cases this trend of there might have been multiple ways to decide a case, and the majority of the court seemed to make the least democratic decision possible in a way that accorded with what appeared to be their political ideologies and loyalties. And so that is very troubling to law forward from a democracy perspective and from kind of a legal system perspective, that we want to think that our judges are always going to be making decisions based on the best interpretation of the law. And what we found is that there were a number of cases in which that didn't really feel like what was going on. There's going to be a quiz on this later. I'm kidding, there's obviously not, this is a ton of information. All of these graphics, by the way, are from our report, which if you're interested, you can read on our website. There's going to be a link again at the end. But I wanted to throw this up here for one specific reason. This is just the rundown of the cases that we talk about in our report. Not going to talk about all of them today. But I want to direct your attention to this kind of middle column, the justice vote column, because on the left you have the majority, and on the right you have the dissent. There's a few cases that were unanimous, there's a few that were 5-2, but the vast majority of these cases with the biggest implications for our democracy were decided by a vote of 4-3. So I think this just really highlights the importance of every single seat on that court and the stakes of our election this spring. Okay, so the first case I want to talk about is Johnson versus Wisconsin Elections Commission. This is the redistricting case or the gerrymandering case. It lasted a long time and it happened before it was up. So I'm not going to try to take us through all of the legal twists and turns. But basically what happened here was after the new census data came in, it was time to draw new maps. And that has gone to the courts, I think, after every census since 1980. It's typically been in the federal courts. And so some parties tried to go to federal court to draw new maps, and some other parties tried to go to the Wisconsin Supreme Court. The Wisconsin Supreme Court took the case, and the federal court deferred to the Wisconsin Supreme Court. So we wound up with the map-making process in front of our Wisconsin Supreme Court. And they kind of out of nowhere, articulated a new standard for what our state maps should look like. Let me take a step back real quick. I'm talking right now about the maps that determine who we're sending to the US House of Representatives, as well as to our state house, right? The state Senate, the state assembly. Those have to be drawn anew after every census to account for changes in population. The idea being that folks should have equal representation, that your vote should count the same wherever you live in the state, and that the boundary lines need to change based on where people are living. So population changes, gotta have new maps. And so that's what this case was kind of overseeing, right? Okay, so the Supreme Court, having not had to deal with this in a long time, decided, okay, we need a rule. What's our rule going to be? And they came up with the least changes standard. So they said, we know we need new maps. We want them to be as close as they can be to the previous maps from the 2010 redistricting, which was, of course, a time when there was single party control of Wisconsin government, and therefore some maps were adopted that were extremely favorable to the Republican Party in the state of Wisconsin. So already the standard that the Wisconsin Supreme Court came up with was pretty favorable to one side, and there was no particular reason for that to be the case. This is an example, I would say, of results-oriented judging. There were other standards they could have adopted. Many states have nonpartisan redistricting commissions. We don't have that, but this is the route that the court decided to take. Okay, so all the parties in the case said, fine, that's the rule, we're going to try to follow it. And after some back and forth, the court initially adopted some maps that were proposed by Governor Tony Evers and his team, which, to be clear, were actually still disproportionately favorable to Republicans in Wisconsin, because he was following the rule, got to have the least changes. But they did at least have 2 majority Black districts in Milwaukee, and it was a little bit less egregiously slanted than some of the other proposals. So the Supreme Court adopted that on the theory that, you know what, this is the one with the least changes, we're going to do it. That goes up to the US Supreme Court, which very close to our spring elections of that year said, you know what, no, you didn't show your work with regard to the Voting Rights Act, so you need to do it again. It went back to the Wisconsin Supreme Court, and instead of conducting an analysis under the Voting Rights Act, what they did is they said, okay, never mind, we're going to take the legislature's members. So they adopted an even worse gerrymander. So basically what they did in the end is rubber stamp some maps that made Wisconsinites' votes unequal. And that's the big problem with the gerrymander, right? Is even though our Wisconsin Constitution says that we should all get an equal vote, it doesn't say that somebody's vote should count more than somebody else. We have these maps that effectively mean that some people's votes count more. And I have some graphics that I think kind of help to illustrate this. So this is from the 2018 election. This is the old maps. But the gerrymander hasn't really gotten better. And this is, I think, a pretty stark visual representation of the problem with the way that the maps are drawn. And that's that you have one party that can win a majority of the votes, like a solid majority of the votes for the state assembly, and still win only about a third of the seats. So that doesn't really look like political equality. And then again, for the state Senate, similar, not quite as dramatic, but still a pretty big discrepancy. That continued in 2020 as well. And again, it may be that the majority party, like in this election, Republicans did win a majority of the votes, but not by as big a margin as the representation in our state legislature would seem to suggest. And I don't have a graphic for 2022, I'm sorry, it's too recent, but it's not that different. Okay. So what's the effect of this, right? So we have these people governing us in Madison who do not really represent the people of Wisconsin in a particularly representative way, I guess, right? They've got constituencies that are typically very safe. There are very few competitive races in this state, which is driving people to both extremes of the political spectrum. It's discouraging folks from even running in some districts because they figure why go get steamrolled. And it means the primary challenges are more dangerous than general election challenges, which is leading to this increasingly heated rhetoric in really all of our politics. And it also just means that things that most people in this state want and the things that most people across party lines want are not getting done. So we have some graphics about that. And this one, I know when I first saw it, I had to kind of squint at it for a minute to figure it out. But this is about Wisconsinites' views on gun safety regulation. And I'll say real quick that all the numbers on this slide and the next one are from polling in late 2022 from the Marquette University Law School poll that Charles Franklin does. The numbers may be a little bit different from poll to poll, but they've stayed generally quite consistent over the last decade or so. So in Wisconsin, we've got 81% of people who support red flag laws that would let the police take guns from people that a judge think are a danger to themselves or others. We've got 79% who think there should be mandatory background checks at gun shows and private sales of guns. And we've got 56%, over half, who think you shouldn't be able to buy a gun until you're 21. We don't have any of these safety regulations in Wisconsin, and it's not particularly likely that our current legislature is going to pass them. Abortion, big issue right now, of course. And people talk a lot about what the court can do on abortion, and that's an important piece of it. But I think it's also important to note that, you know, we have a state government, and the word from the US Supreme Court when it brought down the Dobbs decision that got rid of Roe v. Wade was, hey, states can decide if people don't like this ruling, they should just pass their own laws. And in Wisconsin, sure enough, I guess backing up our current laws from 1849, and it says nobody can get an abortion for basically any reason. 83% of Wisconsinites say, of course, in cases of rape or incest, you should be able to get an abortion. 63% oppose the Dobbs decision, so that would suggest they thought Roe v. Wade was fine. 58% are just sort of generally in support of it. So these are pretty strong Democratic numbers in support, small d Democratic demonstrations of support for just having a modern abortion law. But again, right now in Wisconsin, abortion care is not accessible, and that's due to this old ban that is being challenged. So, you know, the legal merits of that 1849 law are certainly debatable, but the practical reality right now is that nobody's getting an abortion in Wisconsin. So I always like to start with the gerrymandering piece, and that's where it starts as well, because it really sets the stage for everything else we're going to talk about. Because these other cases that make it harder for other parts of government to function, or that see the court kind of deferring to the legislature's legal views and arguments, are all the more troubling because the legislature is not democratically accountable. They might be a little bit less troubling if we had a really fairly elected Assembly and Senate, but we don't, so it kind of exacerbates these problems. So this case, Tigan versus Wisconsin Elections Commission, another one that's 4-3, all three I'm talking about are. This was the case that got rid of drop boxes. This is a case where some basically far-right activists challenged Wisconsin Elections Commission guidance that said that local municipalities could put out drop boxes for folks to vote. We're talking about the 2020 pandemic elections. And they were also challenging the right to have somebody else return your absentee ballot for you. This is something that I think a lot of people have done. If you have ever taken your spouse's ballot to the clerk's office in your town, that is what they wanted people to not be able to do. Oh, I should also disclose, by the way, that all three of these are cases that Law Forward was involved in some way. So in the gerrymandering case, we represented Black leaders organizing communities, as well as Wisconsin Faith Voices, and I want to say League of Women Voters, and we had proposed maps that were adopted. In this case, we intervened on behalf of Disability Rights Wisconsin, as well as a couple of other parties, to try to advocate for voters with disability and try to explain to the court, hey, if you get rid of drop boxes, if you make it hard to get help, you know, returning ballots, this is going to disenfranchise some people in Wisconsin. So ultimately, in this case, the court did rule in favor of the plaintiffs and said that drop boxes were illegal, and also said that nobody can have help returning ballots to their local municipal clerk, their election clerk. And they did that. Well, first they got rid of drop boxes, I believe, between the elections in 2020. And then by November, it was no drop boxes, no ballot assistance return. So this was a ruling that just basically erected barriers to voting, which we consider to be kind of a self-evident attack on democracy, because in a democracy, eligible voters should be able to vote, and we should make it as easy as possible. So the idea that the solution to our election system is to make it harder to vote is just not true. And it's a response also to really kind of the big lie, right? That's what the plaintiffs were saying, is nobody believes in our election system anymore. We need to crack down on all of these security issues, and it's all smoke and mirrors. Our elections are safe and secure. There were multiple recounts and investigations of the 2020 election. No systemic voter fraud, no big problems. We have really well-run elections in this state and generally nationally. So this case was, first of all, kind of a solution looking for a problem. And what it did is it just made it harder to vote, which is not what we want to see.
How did they make the argument?
We're getting to that. So yeah, how did they make the argument? There were a few points in this case where, again, had the court been perhaps less interested in a specific outcome, they could have gone a different way. One big argument on the other side was there's nothing in the statute that says explicitly that drop boxes are allowed. The statute does say that, you know, the clerks get to set up how voting works, and they say that people can vote absentee if they want to. And so the argument that we were making and that other folks were making was, you know what, it's not prohibited. There's a statute that says that nobody can vote in, I think, contravention to the statutes, and there was no statute being broken. This was an example of our decentralized election system, where municipal clerks all around the state have to figure out what's the best way for the people in my city, county, village, whatever, to vote. And a lot of them were saying a secure drop box is the way to make that happen. But the court said, you know what, because it's not specifically articulated in the statute, we're not going to let that slide. So it was a very kind of narrow version of like textualist reading when there were other readings of the statute available. They also, kind of interestingly, this is a little bit technical, so I'm not going to get into all the details, but the folks that were suing about this law had no actual like personal harm coming from it. Like it was not hurting them that people were using drop boxes. And so there were several arguments related to that said, hey, like what are these guys suing about? Normally you have to have a harm to go to court and ask for a remedy, and there just was none. But the court again rejected that argument, despite the fact that a few weeks before they had articulated a brand new standard for what types of harms you have to allege to sue a state administrative agency. But that was for conservation as suing the DNR for a land sale in Lake Michigan. So once it came time to apply that rule to these activists who wanted to erect barriers to voting, they just kind of didn't do it. Which is again, just an example of this really results-oriented judging, as we like to call it. So that's just a couple of examples. Oh, another example would be, on behalf of our clients, we submitted multiple affidavits of voters with disabilities who were explaining, hey, if I can't have someone else return my ballot for me, I literally cannot vote. Some of you might have read the wonderful Milwaukee Journal Sentinel coverage of a man named Tim Carey, who has a medical condition that makes it so that he really can't leave his home safely without a lot of medical equipment and assistance. And he's a voter. He votes in every election. Many folks with disabilities are voters, and it's more important, if anything, for them than anyone else that they're able to have their voices heard at the state government level. And so he spoke publicly, and I believe submitted an affidavit as well, talking about the fact that, if you set up this rule, you're saying that I can't vote. And the court in its decision said there's nothing in the record that suggests that anyone won't be able to vote under our new rules. Which was just not correct. So those are a few of the kind of moves that the majority made to reach this decision. So kind of an obvious direct attack. Wow, this seemed like a long presentation, and I can see that I'm already close to time, so I'm going to try to kind of go a little bit faster. But I do want to point out that in addition to this direct attack on democracy and this kind of loosey-goosey results-oriented style of decision-making, this is another example of, I think, consolidating power at the state legislature. Because it's saying, hey, if the legislature didn't specifically, explicitly authorize something, then it's not allowed. And whatever the Wisconsin Elections Commission thinks, what your local clerks think, doesn't matter. We're throwing that out. Because this had been practiced for a long time. Drop boxes became more popular in 2020, but they weren't a brand new invention. And certainly people have been returning ballots for each other for a long time. So it was really also kind of a mark of disrespect to local decision makers, as well as the administrative agency, the Wisconsin Elections Commission, which is a bipartisan agency, by the way. But it is part of the executive. And it's been kind of a strategy for a few years for certain actors on the right to try to undermine it and weaken its authority. So that's.
I don't see a lot of questions.
Okay.
Don't hold back.
Okay, I won't just start talking faster and faster. I don't know if you can understand me. I do want to add one thing, I guess, to this case, which is that I mentioned that we were representing some folks who work closely with the disability community who are very concerned. And sure enough, after this ruling came down, a lot of local clerks refused to accept any ballot that anyone else tried to return on behalf of somebody else. Even if they said, hey, this is for my brother or parent or whatever who's disabled, he can't come. And they felt their hands were tied, right? They said, the Supreme Court just told me that I cannot accept anyone else's ballot, that you can only return your own ballot. And so Law Forward actually wound up filing a follow-up lawsuit in federal court on behalf of that gentleman I mentioned earlier, Tim Carey, as well as 3 other very courageous plaintiffs who really just, I think, were very brave in putting out their personal stories. They allowed us to represent them in explaining to a federal court, okay, here's our medical conditions, here's why we literally cannot vote under the Supreme Court ruling, which completely ignored the Voting Rights Act and federal protections for folks with disabilities. And very quickly, a federal judge in the Western District of Wisconsin issued a ruling that said, yeah, of course, that part of the ruling was wrong. Federal law does protect voters with disabilities. They have to be allowed to have somebody else return their ballot. And we're actually still seeing a few hiccups with compliance there. But at least we did get that ruling, and the commission, the Wisconsin Elections Commission, has been great about issuing guidance to that effect, because people need to be able to vote. That's kind of the cornerstone of our democracy, right? So that brings us to the last case that I want to talk about. This one was also in the news quite a bit, so some of you might have heard about it, Paul versus Crane. This is the case where a gentleman who Governor Walker had appointed to the Department of Natural Resources Board by the name of Fred Crane refused to step down when his term expired. So Dr. Crane had been appointed to a 6-year term on the board. It expired in, I want to say, May of 2021. And he decided to just not leave. And the governor, meanwhile, was trying to appoint somebody, but our state Senate was not interested in confirming any appointees of the governor, so he was not able to fill the position. So Attorney General Josh Call went ahead and filed a lawsuit and asked the court to remove Dr. Crane from his post. And the court said no. Well, I got up to the Supreme Court eventually, and the court said no. The court said he can stay. And so how is this a direct, and I will get to how they did that. But this is the third case that we think evinces just a kind of direct attack on voters and on our democracy. And why is that? Well, in 2018, Wisconsin voters elected Tony Evers, right? They wanted a change. They had had one-party rule, and they essentially fired Scott Walker. They put Tony Evers in the governor's position. And that suggests that they wanted a governor who would be able to carry out his agenda, work on things that he had said in his platform he would work on. A big part of a governor's job is appointing folks to executive agencies and kind of directing the work that those agencies do. But the governor, in this case, as well as in others that came before that I'm not going to talk about, but in this case, again, made the decision to just weaken the governor who had been elected by a majority of Wisconsinites. And I think it's super important here to notice, to acknowledge that the coalition of voters that elected Tony Evers was disproportionately young, was disproportionately not white, and was disproportionately urban. And this, by the way, is something that applies to the issue of the maps too. When we talk about whose votes count more, it tends to be white rural voters, right? And so when you're talking about decisions that are weakening the governor, it's weakening a governor who was elected by a coalition of more diverse voters than represent the constituency of the majority in our state legislature, which is really kind of a pernicious element of that. So the effect of this decision was that the legislature just gets to stonewall gubernatorial appointees, right? And we saw that with a couple other folks. There were some folks on the state board of regents, the university whose terms had similarly expired, who also declined to step down. All of these people have now stepped down, but it sets a really dangerous precedent for really anyone from any party. In the future, they just think, you know what, I kind of don't want to leave. I still have things I want to accomplish. And it looks like the state Senate is not going to confirm my replacement. The Supreme Court has basically said, okay, that's fine. You can stay. This is another great example of the court making what we perceive to be a results-oriented decision, because there were ways to reach a different decision here. I can acknowledge that there is no statute that is directly on point to the question of what happens if an executive appointee's term expires and he refuses to leave and the state Senate won't confirm their replacement. That's probably, I would guess, because when these laws were being written, folks did not necessarily foresee the kind of breakdown in democratic norms that we've been experiencing over the last few years. So it was this situation where the court was dealing with something weird and it had to figure out a solution. But what did we have in the statutes? We have a term limit that apparently didn't mean anything to the court, but there was a statute that said your term is up after 6 years. And we had a governor who's supposed to be able to make appointments. And bigger picture, again, I mean, we have a state constitution and it sets up 3 co-equal branches of government and it says that everyone's vote should be equal. And so those are the sort of big picture principles that the court ignored in order to reach this decision. And I believe that the kind of the cornerstone of their decision was saying that the seat isn't vacant because he hasn't left yet. Statute says his term is up, if he's still there, it's not vacant, and so the governor can't make a provisional appointee. And they said the governor could make a permanent appointee if he can work with the Senate, which is again, it's one of these paragraphs where you read it and you think that may be theoretically true, but it doesn't feel very reality based for like what is happening in our state right now. So it's just an example where there were multiple paths that the court could have taken, and what it chose was the least democratic option. Yeah, so that's kind of our big takeaway. We think that there were multiple cases in which there were better decisions that the court could have made that would have been more faithful to our democratic principles and our state constitution and our statutes, but they didn't often take that path. So what to watch going forward? We do expect to see continued threats to ballot access and attempts to undermine the right to vote. There are currently a couple of cases pending in the lower courts that address whether clerks can cure errors on absentee ballot certificates. So that's like if you fill out your address and you forget to write your zip code, can they fill it in and count your vote? There's folks on the right who think no, they should not be able to count that vote. So that's being litigated and will likely end up at the Supreme Court at some point. There will likely be additional attempts to sort of gum up the works of our election administration system. And then again, I mean, as long as the legislature is this powerful, we do expect to see people attempting to kind of shore that up and keep that going and hamstring the work of other bodies of government, as well as particularly administrative agencies and local government. There is particularly a challenge. I'm just looking at my notes here. There's something called the non-delegation doctrine, which is kind of a recent darling of the right, which says that the legislature cannot delegate any power to other entities, state agencies, or local government. It has to explicitly tell them by statute what to do. That was at one time kind of a legal principle the governments relied on. It hasn't been in Wisconsin since 1928, and it's been discredited in pretty much every state, I think every state, for a long time. And the reason for that is that if you think about how a modern government works, it would be totally dysfunctional. For example, how could you have like a hunting season or any sort of environmental regulation if the legislature had to sit down every year and write out detail by detail, okay, here's exactly how many deer everyone can shoot. Or like taxes. Do we really think that our state legislators are capable of handling our tax returns or figuring out every detail of how that should work? That's just not how our government works, right? We elect our state representatives to sort of think big, to respond to our concerns and to pass laws. And then we have administrative agencies that have subject matter experts that can put those into effect. And if they get it wrong, there's accountability and oversight mechanisms from the legislature, but they are generally better positioned to actually make government work for us. So a challenge to the ability of the state legislature to delegate its authority is really, we believe, a challenge to government as a principle, like a challenge to having a functional state government at all. There's of course other high-profile issues that could come to the court, including bodily autonomy, the right to abortion and reproductive health care, as well as that gerrymandered map. If the court flips, there will be a challenge to the existing maps that we have, which could be exciting to watch. So I guess before I'll go back to this cute slide for a second, because I do just want to say that we do think it could be different, and I've hinted at this a little bit, but we think that the Supreme Court could play a much more vital and robust role in bringing to life the political equality and democratic accountability that's baked into our Constitution, and that I think we all think that we should enjoy. You know, really basic principles like everyone who's qualified to vote should get to vote, everyone's vote should count equally, government should work for the people. These principles are embodied in our Constitution, and it's our responsibility as voters and citizens to make them come alive, as well as the courts. So, you know, in some ways, we're lucky that we live in a place where we do elect our Supreme Court justices because they work for us and we get to pick who they are. And I bet everyone in this room knows this, but I do like to always point out that the gerrymander does not affect the Supreme Court races because it is a statewide race, so everyone's vote actually does count equally. So that's all I got. You've all been very quiet tonight. Folks have questions.
I have a question about the man who's so distant if he can get to the voting. Can he send a mail-in ballot? And if so, would they be using that argument that, well, he can mail in his vote, his ballot? I don't know if I explained this.
No, I think you did. And there was an argument that people also have to mail their own ballot. And so what he explained is that he couldn't physically, like he can't rip an envelope. So somebody else has to do that. And interestingly, one response that came in from the folks who were trying to affect this change was basically, but if somebody emails it for him, like who's to know? Which is basically saying, it's, you know, maybe you can get away with voter fraud if they say that you can't have someone else mail your ballot. Yes, sir.
But Elizabeth, do you have any idea, this is not a legal question, do you have any idea how much taxpayer money was used to do the recounts of the 2020 presidential election for Wisconsin?
Ooh, I don't. The Wisconsin Democracy Campaign is really good about tracking like money in politics. So I would suggest maybe looking to see if they have numbers. I'm gonna go ahead and guess a lot.
So from feeling.
Yes.
Yeah, is there a state somewhere that has managed to solve the gerrymandering problem?
So a lot of,
How would they have done this?
yeah, so many states actually do have nonpartisan redistricting commissions. That can be affected by statute. In some states, it's been affected by ballot initiative, which is something that we don't have here. That's where voters can directly put a question on the ballot that is then legally binding that says, hey, should we, instead of letting our legislature draw maps, should we have a nonpartisan commission that does it? I believe in Michigan. But again, we don't have a ballot initiative process, so the voters here can't do it. There have been local referenda in Wisconsin, just asking folks to weigh in on if they would like that, if they would like the nonpartisan redistricting commission. And I want to get the number right. 55 out of our 72 counties have passed resolutions calling for nonpartisan redistricting. So it's something that people want. It's something that works in other states. But again, the only way to get it here is for the legislature to pass a law to make it happen. So. Well, if that's it, thank you so much for coming. Our website is up here.